glad you can make it to this meeting, Mr. Livingston.
Cut the pleasantries and let's get to business, Ogden. This here's a subcontract. With this, you have control over all steamboat trading and commerce at the New York ports along the specified routes. With this, that shipping company you have with Thomas Gibbons should be getting busy pretty soon.
Yes, it should. I'm glad me and Thomas can share the monopoly over steamboats.
In 1815, by the time Aaron Ogden had received exclusive navigation rights along New York ports from Robert Livingston, who had a monopoly granted by the New York state, he and Thomas Gibbons had been business partners for over 3 years and had been running a shipping company based in New York. However, this partnership came to a screeching halt in 1819 when Gibbons began operating a competing steamboat, the Bellona, on Ogden's shipping route.
What is this?
That's my steamboat.
And why is it in my waters?
Your waters. Last time I checked, the Constitution clearly states that Congress has the ultimate power over interstate commerce.
No, Congress merely has the right to uphold basic regulations. According to Livingston, you cannot be using and navigating your steamboat in my waters. I want you to shut it down.
And if I don't?
I'll be suing you, and if you don't like it, you can take it to court.
Oh wait, what's that for that room, huh? Trick question, that's a parking lot.
I guess I'll be seeing you in court.
The New York Court of Chancery will now commence Gibbons versus Ogden's. Petitioner, state your grievance.
Your Honor, Thomas Gibbons is currently operating steamships on the steamboat monopoly granted to me by a subcontract approved by the state of New York. Gibbons's steamboat must be shut down because I have the right given to me by the state to operate exclusively on the specific waters.
Defendant, you may now proceed with your argument.
Thank you, Your Honor. I believe that the steamboat monopoly Mr. Ogden is operating on directly conflicts with the federal law and Congress, the law that Congress has sole power over interstate commerce and navigation routes. Giving states congruent power over interstate commerce on waters results in confusing and contradictory law.
The claim and argument by the petitioner and the defendant have been considered. The New York Court of Chancery and Appeal Court for the correction of errors both rule in favor of the defendant, Aaron Ogden.
But Your Honor,
Aaron Ogden's sublicense grants him exclusive rights to call at New York ports. And you, Thomas Gibbons, must seal sailing to these parts. Case dismissed.
you may have won this round, but I'll definitely be appealing to the Supreme Court.
So be it, if that's what it takes to make you see sense.
We gather here today in review of Gibbons versus Ogden. Appellant, please summarize your case.
Chief Justice Marshall, according to Article 1, Section 8, Clause 3 of the Constitution, Congress had national power over interstate commerce. Therefore, no single state should have the authority to regulate the steamboat monopoly.
Appealee, state your response to the appeal.
With all due respect, Chief Justice Marshall, the states has always passed laws regarding interstate navigation. Claiming that Congress has no power to regulate commerce is not only preposterous, but exceeds the outlines of the Constitution.
Article 1, Section 8, Clause 3 of the Constitution is indeed the Commerce Clause. Commerce is much more than trade. It is a communication between nations and parts of the nation. The Supreme Court of the United States therefore overturns the decision of New York State courts and rules in favor of Thomas Gibbons. The federal government's power to regulate commerce may be exercised to its utmost extent and acknowledges no limitations other than are prescribed in the Constitution. Court dismissed.
The significance of the ruling of Gibbons versus Ogden was immense. It defined the future of not only steamboat routes, but also interstate roads, canals, and technologies still being developed. The enforcement of the Commerce Clause also meant that Western expansion would be precipitated by the U.S. Congress. The principle of federal power over interstate commerce eventually allowed Congress to ban child labor, set minimum wages and other working conditions, and in 1964, Congress would outlaw racial bias against customers by local businesses. Ultimately, Gibbons v. Ogden proved that the federal judicial system had powers exceeding what was outlined in the Constitution, and overturning a state court's decision established federal supremacy and precedent seen in Chief Justice Marshall's later court cases.
I suppose the constitutionality of interstate navigation and commerce has finally been cleared up then.
Yeah, I suppose it has. Good being partners with you.